Senator Lindsey Graham must call the anonymous CIA so-called whistleblower to testify if the House impeaches President Donald Trump. Hello, this is Robert Romano, Vice President of Public Policy with Americans for Limited Government, dailytorch.com. Hit that subscribe button. Today we're going to be talking about Senator Lindsey Graham. He's the chairman of the Senate Judiciary Committee, and why it is probably incumbent upon him to call this so-called whistleblower to testify before his committee. Now, that can be done behind closed doors. He's said to be a CIA agent, and I think there would be some legitimate concerns with concealing this individual's identity. However, at the moment, under House Speaker Nancy Pelosi's impeachment inquiry, this witness is not being called to testify and is not being subjected to cross-examination. And I think that that is a serious breach of due process under the Fifth Amendment and also under the Sixth Amendment, the right to confront one's accusers. Now, whether or not the impeachment process is a criminal matter, which would have applicability with the Sixth Amendment, it's certainly been debated for many, many years throughout American history. But leaving that aside, the Senate is in charge of its own process and has sole power under Article 1, Section 3, sole power to try all impeachment. So if the House goes through with an impeachment, the Senate's going to get to determine who the witnesses are and who calls them. So let's unpack this a little bit here. The right to cross-examine witnesses, to have counsel present, and to confront one's accusers are pretty much inherent, and they're ingrained in our constitutional framework. And that's why in criminal proceedings, you don't have anonymous accusations that are made. People have to file police reports and so forth. But in this case, President Trump's impeachment, you have an anonymous CIA whistleblower who has received zero scrutiny for his allegations that President Trump was somehow withholding military assistance from Ukraine in his July 25 conversation with Ukrainian President Volodymyr Zelensky. Unless Trump was telling Zelensky, unless you investigate Joe Biden's son, Hunter Biden, Burisma Holdings, which Hunter Biden was serving on the board of directors of. Burisma is a natural gas firm in Ukraine. Now, the whistleblower allegations were basically put into this memo form on August 12th, 2019, and it reflected this conversation between President Trump and Zelensky. This was released declassified on September 24th. Now, the CIA whistleblower has been reported on October 1st by the New York Times to be a CIA officer who detailed to the White House at one point, but may not have been at the White House when this phone call took place. In the allegations, he says that he had received this information from multiple U.S. government officials and that he was not a witness to the events that took place. And therefore, it was admittedly hearsay allegations, and I think that that's a problem, because you can't confront this accuser. He's an anonymous CIA agent who submits this whistleblower complaint, and he's trying to hide under the veneer of whistleblower protections. But I don't think that those whistleblower protections set forth in federal law are applicable to a whistleblower in an impeachment. If you're a witness to an impeachment or to impeachable conduct, you're going to be called to testify before the House and before the Senate. That's the most important person who's going to be called as the witness to these allegations. I think that that's very important that we hear from the witnesses here, whoever they might be, whoever helped to draft this memo. If they happen to be on the House Intelligence Committee as a member or staff, they should probably be called to testify as well. And the reason for that is because these allegations contain numerous factual errors. This is a story from Sean Davis at The Federalist, a very neat summary. The complaint from so-called whistleblower is riddled with gossip and blatant falsehoods. Quote, the formal complaint from an anti-Trump whistleblower alleging various crimes by President Donald Trump is riddled with third-hand gossip and outright falsehoods. The documents were declassified by Trump Wednesday evening and released to the public Thursday morning. The complaint, which was delivered to the chairman of the House and Senate Intelligence Committees, follows the same template used in the infamous and debunked Clinton campaign-funded Steele dossier. Rather than provide direct evidence that was witnessed or obtained firsthand by the complainant, the document instead combines gossip from various anonymous individuals, public media reports, and blatant misstatements of fact and law in service of a narrative that is directly contradicted by underlying facts. A footnote in the document even boasts about its use of ample open source information, quote. Contrary to news reports asserting that the complaint included volumes of information incriminating Trump, it is instead based entirely on the president's July 25 phone call with Ukrainian President Volodymyr Zelensky and various public media reports. Quote, I was not a direct witness to most of the events characterized in the document. The complainant confesses on the first page. Instead, the complainant notes the document is based on conversations with, quote, more than a half dozen U.S. officials. Those officials are not named and their positions are not identified anywhere in the letter either. The complainant begins by falsely characterizing a July 25 phone call between Trump and Zelensky, the transcript which was released by the White House. Trump made a, quote, specific request that the Ukrainian president locate and turn over servers used by the DNC and examined by the U.S. cybersecurity firm CrowdStrike, the complainant alleges. But a review of the transcript of the call shows that Trump mentioned CrowdStrike once during the call. He never made such a request about locating and turning up the servers to the U.S. The complainant also falsely alleges that Trump told Zelensky that he should keep the certain current prosecutor general at the time, Yuri Lutsenko, in his current position in the country. Quote, the president also praised Ukraine's prosecutor general, Mr. Yuri Lutsenko, and suggested that Mr. Zelensky might want to keep him in his position. The complainant alleges, based on gossip he says he heard from unnamed White House officials. But Trump made no such suggestion to Zelensky, according to the transcript of the phone call. While Trump did say it was, quote, unfair that a prosecutor who was, quote, very good and was shut down, it's not clear that Trump was even referring to Lutsenko, as a previous prosecutor named Viktor Shokin was fired after he opened investigations, he says, into a Ukrainian energy company that placed Hunter Biden, Democratic presidential candidate Joe Biden's son, on its board. And Trump directly references Shokin later in the conversation. There's a quote, there's a lot of talk about Biden's son, that Biden stopped the prosecution, and a lot of people want to find out about that. So there are numerous factual inaccuracies in the whistleblower complaint, and as a result, this so-called witness probably should be called to testify, and whoever helped to draft this memo, they should also be called to testify. They could be fact witnesses here. In fact, mutual legal assistance was requested in the phone call by both Trump and Zelensky of matters of mutual interest, including Ukraine's potential role in the false Russiagate allegations that President Trump and his campaign were somehow Russian agents. And there was also a request by Zelensky to Trump about the U.S.'s potential role in corruption in Ukraine, where Zelensky's explicitly asking for assistance, any information that can be provided, including the firing of Ukraine's top prosecutor at the time at the behest of former Vice President Joe Biden. Joe Biden was caught on camera at the Council on Foreign Relations at an event stating that he had Viktor Shokin fired, and he had conditioned $1 billion of foreign aid and loan guarantees to Ukraine unless the prosecutor was fired, and surely enough, he was fired. And that's what Ukraine is asking the United States President Trump for assistance in, pursuant to mutual legal assistance treaty with the United States. Now, again, we can argue about the extent the Fifth and Sixth Amendments even apply to impeachment proceedings. And at the end of the day, Pelosi is going to do whatever she wants. And ultimately, our institutions will suffer for the consequences of that for a very long time. But in the immediate future, it's sufficient to simply consider this. We are having an unprecedented case of an anonymous secret witness at the center of a House impeachment of a sitting president. But the House is just one body. The Senate is completely in control of its witnesses, and they can call whoever they want. And that includes Senator Lindsey Graham, chairman of the Senate Judiciary Committee. Rule number 6 of the Senate's impeachment rules, rules and procedure and practice in the Senate when sitting on impeachment trials. Rule 6 states, quote, the Senate shall have power to compel the attendance of witnesses, to enforce obedience to its orders, mandates, writs, receipts, and judgments, to preserve order, and to punish in a summary way contempts of and disobedience to its authority, orders, mandates, writs, precepts, or judgments. So the Senate can call this so-called whistleblower to testify, and there's going to be no protection for that individual under whistleblower law. If you look it up, you're going to find out that the only protection is that the Inspector General is not going to disclose the identity of this individual. The law and the code states that unless that the identity should be protected, quote, unless the Inspector General determines that such disclosure is unavoidable during the course of the investigation, or the disclosure is made to an official of the Department of Justice responsible for determining whether a prosecution should be undertaken. Now, on that count, Attorney General William Barr, he should consider the coordination between the witness and the House Intelligence Committee staff and as a potential source of leaking classified information. The fact this was turned up in the New York Times and the Washington Post. This conversation between Trump and Zelensky, that's classified, and the information from the memo from this whistleblower complaint got leaked to the Washington Post and the New York Times. That's illegal. This contained classified information, and it shouldn't have happened. So do you have the crime that was committed here, and the one that Barr should look into is this classified information leak, which appears to come from the Congress or somebody in Congress who had access to this memo. The whistleblower also directly targeted Barr and U.S. Attorney John Durham's ongoing investigation into foreign intelligence agency involvement in the false, phony Russiagate allegations that Trump and his campaign were some sort of Russian agents. These were false allegations by the intelligence community, by the so-called former British spy Christopher Steele, and his allegations that Trump was a Russian agent, that the campaign had full knowledge and support of the Russian hack of the DNC and putting the emails onto WikiLeaks. This got encapsulated in a FISA warrant application that was granted 4 times that gave the Justice Department unprecedented access to a presidential campaign's emails, text messages, phone calls, and other documents. And it went all the way from October 2016 past June of 2017. And it's an unbelievable abuse of power. You had the Obama administration spying on an opposition party in an election year. This can't be happening in America, but here we are. It's therefore now the Senate's job to get to the bottom of these accusations, these new allegations. We know from the Robert Mueller report on Russian interference in the election that there may have been a DNC hack and a John Podesta hack by the Russians, but the Trump campaign and President Trump, Paul Manafort, Carter Page, George Papadopoulos, Michael Flynn, everyone in the campaign, Roger Stone, nobody had anything to do with the hack. There was no conspiracy between Trump, his campaign, and Russia to hack the DNC and Podesta emails and put them on WikiLeaks, which means that the Steele allegations were false, and that the Senate needs to get to the bottom of that. Senator Lindsey Graham has promised to get to the bottom of that. William Barr is investigating that. John Durham's investigating that, and that's what the whistleblower is trying to do: is to discredit the Barr investigation, the Durham investigation, and the Inspector General report due any day now by Michael Horowitz, Justice Department Inspector General, into these FISA warrant abuses and FISA abuses more generally, spying on a presidential campaign. This can't be happening in America. And again, the Senate has the power to call its own witnesses, and it can't be barred by whistleblower protections or from performing its constitutional obligation under Article 1, Section 3, which states clearly the Senate shall have sole power to try all impeachments. This is the only way for the Senate. Now, they have to call this whistleblower to testify, because that's the only way for the Senate to truly determine if the whistleblower filed a false complaint, which would be a serious offense, and who might have helped. And if that includes members of Congress or staff members, they should be called to testify too. It's up to Graham to do that. Fortunately, Senator Graham has just issued a statement where he told reporters his thoughts on the use of secret witnesses in the House and President Trump's description of this farce as a lynching. Now, let's take a listen to that.
What is your reaction to that?
I think it's pretty well accurate. This is a sham. This is a joke. I'm going to let the whole world know that if we were doing this to a Democratic president, he would be all over me right now. Not one person has asked me a question. What do you think about the fact that President Trump doesn't know who his accuser is? What do you think about the fact that the Republican minority cannot call witnesses, that everything's done behind closed doors? I can only imagine if this were a Democratic president, what you would be saying to me right now. So it shows a lot of things about our national media. When it's about Trump, who cares about the process, as long as you get him? So yeah, this is a lynching in every sense. This is un-American. I've never seen a situation in my lifetime as a lawyer where somebody's accused of a major misconduct who cannot confront the accuser, call witnesses on our behalf, and have the discussion in the light of day so the public can judge. If this continues in the House, it's a complete sham, and I will do everything I can to make sure it doesn't live very long in the Senate.
Well, there you have it. Senator Graham promises to get to the bottom of this, and I'll leave you with the close here because I think this is really, really important that the president be allowed to confront the accusers. If they're members of the intelligence community, or they're members of Congress, or they are staff members on the House Intelligence Committee, they should all be called to testify so that we can analyze these allegations of high crimes and misdemeanors. That's what the impeachment is supposed to be over. So if this is a criminal process, we should have due process, and that includes the right to confront accusers and to engage in cross-examination, because I think if you start investigating this so-called whistleblower and who put these memos together, you're going to find out that there was a lot of coordination between the intelligence community, perhaps the inspector general at the intelligence community where this complaint was filed, and members of Congress to formulate these accusations and to try to engage in a legislative coup to remove President Trump from office. And here's the closing. This is simply too important. We're talking about legislative means to overturn the 2016 election. Cross-examination is not retaliation. It is a prerequisite to due process under the Constitution, especially in an impeachment. Chairman Graham, it is up to you to uphold the Constitution, and it looks like he's going to do that. That's the commentary. This is Robert Romano, Vice President of Public Policy with Americans for Limited Government, dailytorch.com. Hit that subscribe button, ring the bell for notifications, and have a good day.